Hello, everyone, and welcome back to the University. Today we have the next hearing in the Raymond Davis case. This occurred on January 17th, 2020, so it's the first hearing we have of the new year. And as many of you so accurately predicted, this is a motion to dismiss Attorney Mueller. Who saw that coming? Let's see what happens. I hope you enjoy.
Hello, Stacy.
Good morning.
Alright, we are going to
Ms. Davis here yet?
handle Mr. Davis's case first.
Okay.
Ms. Holmes, can I have your bar number, please?
5391.
5391.
Old as dirt. Sorry about the snuffle.
Oh, that's okay. And then Violet, did you send me anything? I didn't have anything in my email.
Just what we sent yesterday. But I have,
Did you send? I didn't see what you sent her yesterday.
because I sent it just to the judge.
Oh,
So what she said is there was going to be, I said, hey, if you want to write
I
anything
saw that.
in opposition to Stacy, and she said, well, I don't wanna send my opposition to Stacy before she filed it. So I said, okay, and as soon as Stacy filed it, please send her the opposition immediately. But, Mr. Dawson, I checked my email and I didn't have anything. I'm wondering if it went to spam?
Yeah, I sent it to you right at 5:05 yesterday afternoon.
I do not have anything. Alright, so we'll deal with that one.
Okay.
Alright. Okay, so let's go on the record, please, to C-193, sorry, this is C-342946, State of Nevada versus Raymond Davis. Mr. Davis is present in custody with Mr. Mueller. Ms. Collins is also present on behalf of the state. The defendant has filed a motion to, a couple different motions to dismiss Mr. Mueller. Where are we at on that?
I'll submit it.
Okay, so Mr. Davis, you filed a couple different motions. One of them was filed, I want to say either early this morning or very late last night, which is several pages. I have had the opportunity to read it, but I don't think that Ms. Collins probably had the opportunity to read it. But I guess why I'm saying that is because it deals with a lot of different issues. It's a motion to dismiss counsel, but there are a lot of different issues in it. So for today's purposes, I need to put on the record the issues that you feel. We're coming up on trial, as you know, and that's a firm set, which I've always explained to everybody, and I explain it.
I like to object to trial due to my double jeopardy. The trial ended in a double,
Just one second. So today it's your motion to dismiss. So if you'd like to file a motion a motion to dismiss based on double jeopardy, I'm happy to hear that. But today we're here on a motion to dismiss counsel.
I got the motion for double jeopardy here. And today wasn't set for dismissal counsel, they had me set for the 22nd.
Right, I moved that because I can't have a motion to dismiss counsel right before trial. So if Mr. Mueller is off this case, he needs to know that now, so he's not spending, prepping and moving all of these cases.
I had 4 witnesses that wanted to come in and testify to the ineffective counsel I had.
Okay, so
Because due to the fact that I'm never allowed to be heard.
Mr. Davis, I need to hear about your motion to dismiss counsel, so please discuss that.
Your Honor, can I have my witnesses come in?
Okay, there are no witnesses in a motion hearing. If you'd like to request an evidentiary hearing, that's fine. Today is your motion to dismiss Craig Mueller. Why would you like to dismiss Mr. Mueller? Would you like to put anything on the record?
Yes, I got a statement.
Okay?
Yeah.
Now, I don't want you to just read what was in the motion. I've read the motion. So if you have anything you'd like to add, I've read your motion in completeness. So I know what's in your motion. So you can't just read from the motion that I've already read. If you would like to talk to me about specific points, I'm happy to hear those.
I would like the second motion, because this one wasn't prepared in time.
What are the issues that you're having with Mr. Mueller as your attorney?
Well, the first issue is he saw me for 20 minutes since I hired him. I had a 20-minute visit. The sheriff, Laverne, on December the 8th, escorted me to the counseling area, and I had a 20-minute meeting with him, and it wasn't even about my case, it was about getting $3,000 for some private investigator that I paid before that did no work. She came back and got me 20 minutes later, and she says, geez, that was fast. It's all documented. It was December the 8th. That was my only visit with Craig Mueller. I have had a total of 4 minutes of phone calls. 4 minutes of phone calls. I have been trying to get him to help me get motions in, pretrial motions. He refused to put in any pretrial motions besides ones that's just totally drawn dead, like the bail motion, no good. Obviously, I mean, I wasn't gonna get a bail. When I got a bail, it was excessive bail, so it was the same as no bail. Also to recuse a judge, I didn't ask him to put that in.
You did or didn't ask him to?
I did not ask him to put that in. After your argument, he went on his own. You could look at the tape. I never asked him. I didn't say one word. That was December. That was November the 4th.
So Mr. Mueller moved to recuse me completely on his own, and it was not at your request?
It was not at my request. I did not ask him. And if you look at the transcripts, look at the video, I never asked him. After you were yelling at me and all that, he moved on his own to recuse you.
Have you had an opportunity to review that, Jazz? Because I have, and so did the judge who, at the recusal hearing, and I never raised my voice one second.
Okay. Well, you were very agitated. You came across very upset with me. You've been very upset at me with maybe every hearing. I haven't raised my voice. I haven't said anything. I sat silently while I have been scolded.
Does that count the time that you were screaming the F word over and over again?
I did that.
Oh,
I did that.
But that was with a calm voice?
Yeah. And then I went to Competency. I had some issues then. I came back 100% competent. You don't know what was going on in my life. A lot of stuff was going on in my life, not pertaining to this trial, but a lot of personal stuff was going on. I was very upset. You know, after that happened, I did apologize to the court. I apologized to everyone. And when I look at NRS 178.405, if a person is deemed incompetent, the trial should suspend. Paragraph 1 is suspend the trial. You called a mistrial. I don't know why. I didn't want a mistrial. I want the trial to continue. Anyway, I went to Competency and I passed it. Should have came back. The trial should have continued.
So the jury...
I wanted on the record that it was suspended.
Okay, the jury should have waited and missed their jobs and their works and their families for weeks?
No, Your Honor. Your Honor, Competency, my competency testing was 30 minutes. 30 minutes. It was 30 minutes with one, and it was 30 minutes with what? It wouldn't even took a weekend to finish competency. Why, if the NRS 178.405 says suspend, I looked through thousands of pages, hundreds of pages of case law, and I have never saw it called a mistrial. So it was, if it was suspended, I could see if it was court error or it was a mistake to call it a mistrial, but to punish me, and I mean.
Okay, so what would you like to say in regards to Mr. Mueller's presence?
I have nothing against Craig Mueller. As you know, I have always spoke highly of him. I've always considered him like a friend, but I mean, to not do anything for 4 months is beyond, I mean, it's totally ineffective. How can I go to trial with a lawyer that hasn't even, he don't even have the transcripts from the last trial. He has no transcripts. He tells Terry, she goes to the store, I mean, goes to the office. He tells her it's in storage and all this type of stuff. I mean, my speedy rights, no motion for that. Double jeopardy, because, I mean, I'm pretty sure it could have been suspended. It wouldn't have took a weekend to go through competency with me.
What would have happened if you were deemed incompetent?
If I was deemed incompetent,
Right.
and then there's another NRS if I'm deemed competent. incompetent, there's more testing.
Right,
And
but what would we have done with the jury? And how was I supposed to know what the doctors were going to say?
Your Honor, I'm just saying, this is the NRS. This is the Nevada revised statute. I'm not making this statute up.
Nevada, you're saying 178.045?
Yes, no, 178.405, paragraph 1. It's there. It's plainly there.
Okay.
So that means
It does not
manifest,
say at all what you're saying. It says, I'm sorry, mister.
what does it say?
It says, anytime after the arrest of a defendant, including without limitation, proceedings before trial, during trial, when upon conviction the defendant is brought up for judgment, or when a defendant who has been placed on probation or whose sentence has been suspended is brought before the court, if doubt arises as to the competence of the defendant, the court shall suspend the proceedings, the trial, or the pronouncement of the judgment, as the case may be, until the question of competence is determined. It does not say that the matter should be continued. Suspended means stopped.
I said suspended.
Yeah, but you're saying, what you're saying that statute says is that the trial should stop, and that we should continue it, and then once you're competent again, we should start from scratch. That's not what the law says. So let me tell you let me try to explain something about motions. And this is something that comes up a lot. So Mr. Mueller is in charge of what motions he deems appropriate to file. So if he knows that some of the motions that you'd like to file are not valid legal motions to file before the court, then he will not file them. I know that you believe that there are certain motions that should be filed, and I understand that. But that's why people have attorneys. So he, as the attorney, as someone who went to law school, who's been doing this for almost 30 years, knows which motions are legally valid. And there are certain roles that the attorney has in the case. And as your attorney, he makes the decisions on what motions to file. If he has not filed those motions, he has valid reasons. Mr. Mueller, are there motions either A, that you will be filing, or B, that the defendant has asked you to file, but that you have not found a valid legal reason to file, please, sir?
Yes, on all three counts. There are several groups of motions. Mr. Davis is bright, articulate, insightful, and a very skilled advocate for his position. He unfortunately has an experience of interpreting some of the key words, just as you pointed out here. We are doing a new bail motion. Mr. Polaris in my office is working on it. We have several other motions. He submitted a very large package of information, all of which facially make logical sense and have to be very thoroughly vetted to go through and put together. Mr. Polaris is going through them. I anticipate getting 2 or 3 of them on file when I believe them to be meritorious. He's frustrated, as you can tell, at the slow pace of the proceedings, but it is my assessment of Mr. Davis's case that very little is to be had except for preparation and being ready to go to trial, which will almost certainly, as you know, tends to bring about resolution on the vast majority of cases. I do not anticipate any of the motions he's made or any of the concepts he's advanced so far as going to be dispositive sufficient to convince Ms. Collins to resolve the case on very favorable terms ahead of a trial date.
Okay.
Your Honor,
Yes, sir.
a bail motion? He wants to do a bail motion? We're 18, 20 days from now you want to do a bail motion?
Mr. Polaris is going through.
Your Honor,
Okay, well, hold on, let Mr. Mueller finish, and then
It
I'll
was
hear from you.
my assessment that Ms. Collins and her zealousness for her cause glommed together every Ray Davis from the western regions and threw them all in one bail motion. Many of the accusations in the bail motion or Mr. Davis's criminal record are not, in fact, this particular Ray Davis. The practical problem with refuting that now is we actually have to go through and find out which Ray Davises are his and which are not. A subject that has caused Mr. Polaris to lose several hairs. All right, now he's pulling his hair out, trying to put together a proper bail motion. His defense is contentious, both Mr. Davis's and this officer of court, that the current bail is in fact deeply excessive.
Your Honor, I have no problem with your bail that you said. You said it, you had your reasons for saying it. The names that were used, and that was fabricated, are known not to be me. They knew, the DA knew that wasn't me. It was used to make me look like a bad person, then up my bail. You made the bail, you set the bail, I've been sat in jail for 4 months, okay? I don't think a bail motion needs to be heard for 20-something days to go to trial.
Okay.
I mean, that is ridiculous. She made that, the FBI got this material, let them figure out why they came up with all these aliases, all these FTAs, all this stuff that they put on me. Your Honor, in regard to NRS 178.405, it is suspend the trial, and the trial may proceed once the person is found competent. I am in double jeopardy. I have been prosecuted 3 times. This is the 2nd time. There is not manifest available for a mistrial that have been called. I asked for counsel. Counsel was right next to me. You appointed counsel with the idea that if I can no longer continue, that counsel could take over. I asked for counsel. You refused to give
So,
me
Mr.
counsel, which
Davis,
violated my
time out.
6th Amendment
One
right.
thing that you have to try to do is talk about the facts that actually happened in the case. So Mr. Klaus, when he was appointed to be your standby counsel, told you and told the court, sir, if at some point you no longer wish to represent yourself, I cannot, in the middle of this trial, pick up this case and take over. That is on the record several times. It was explained to you that if you wanted counsel, he would not be able to, in the middle of that trial, take over your case.
Your Honor, I'd like to see that on the record because I never got that. Also, there were several hearings that I wasn't in, ex parte conversation between you, DA Stacey Collins, that I was not available
When?
for. Let me get I can get the dates if I
Sure.
can remind you.
And if you weren't there, then how would you know about them?
Because I got the records, the court records.
Okay.
Okay, I'll tell you. Here we go. My glasses. Okay, Your Honor, so I was pro se, 100%. And we have the one I was there at. Motion to withdraw counsel, which Jay Maynard was there, Craig Mueller was not there. All pending matters, I was not there.
What day?
That was the 4th. That was after that.
What day?
That is September the 4th, 2019.
Okay, and what does it say?
It says defendant notice motions and motions to withdraw as attorney of record. I was there.
You were there?
Yes, but
Okay,
then,
so why don't you go to the one where you weren't
Okay.
there that you're saying?
okay, here we go. 2000, the same day, okay, I don't know how two hearings could be held at 9 a.m. Okay, 09, 05, 2019, notice of witnesses and experts. That was the 5th, September 5th, I was not there.
Can you bring me can the marshal bring me the please?
Not to interrupt, Your Honor, but I think that's the state's filing of a written notice of witness.
This is not a
It's
court
not a
hearing,
hearing.
Mr. Davis. This is the date they filed their notice
Okay.
of witnesses.
Okay.
This is the problem, sir, is that you come up with these things in your head that aren't happening. There has never been a time
Okay.
where anyone has been in court, and if you weren't there, then it would be continued for
Okay.
your presence.
Right here, Your Honor, 909, evidentiary hearing, matter heard. I was not at evidentiary hearing.
You weren't at an evidentiary hearing.
No, I didn't.
When the previous alleged victims testified, you weren't there.
Oh, that alleged, those.
Oh, yeah. There you go.
Okay. And all pending matters, all pending motions?
So what you're looking at, sir, is the register of actions. You're
Right.
not looking at the court. So on the register of actions, it shows every time this case has been on. If you click on those links and go to the minutes, it will show who's there.
Okay, Your Honor, I would like to exercise my 6th constitutional right to represent myself. I am competent. I do not need counsel. I would like to move forward without counsel and represent myself. as afforded to me by the Sixth Amendment of the United States, the Bill of Rights.
Okay, so according to Tanksley versus State, 113 Nevada 997, a defendant can strip themselves of their right to represent themselves if they have not behaved or shown the court that they can follow procedural guidelines in a criminal trial. I let you represent yourself in the previous trial where I watched you become very volatile and emotional multiple times. You refused to follow court rules, court procedures, commented towards the jury multiple times, very inappropriate comments. You fell to your knees at one point crying. At one point you repeatedly screamed the F word over and over and over again. You took steps towards the district attorney. My marshal got into the middle. Another time you told me that
That's not true, yeah.
you were
I did
coming.
not step forward to the,
That's a objection, you should not argue with the judge.
and New York Marshal did not come between me.
Okay.
Also, Your Honor,
I'm not done, and when I'm done, you can talk.
okay, thank you.
In that case, the court stated, this court in the prior trial, which was last month, observed the defendant's conduct in representing himself, and to say the least, it was disruptive. A defendant's right to self-representation does not allow him to engage in uncontrollable and disruptive behavior in the courtroom. United States versus Blewett, Ninth Circuit. The judges have the obligation to control courtroom proceedings. In determining disruption, the defendant's pretrial activity is relevant if it affords a strong indication that the defendant will disrupt the proceedings in the courtroom. I don't have to just rely on your pretrial conduct. I actually have conducted a trial in this case and have had the opportunity, which is rare, to see your behavior during the trial proceedings themselves. I had absolutely no ability to control those proceedings because of your outbursts, your behaviors, and how you consistently spoke to the jury about witnesses, the prosecutor, and myself. So because of that, it is within my discretion, after you have made those showings to the court, to decide whether or not you can represent yourself. So your request to represent yourself based on the factual things that I have seen and put on the record pursuant to the Tanksley v. State case is denied.
Your Honor,
Yes, sir.
if I was so disruptive in your court, as you say I was disruptive, NRS 175.3
Attorney, please,
Three.
it is my advice that you remain silent.
387 gives you the right to remand me, hold me in contempt of court, gag or bound me. None of those procedures was taken. Nothing. You punished me in no way.
Right,
when
because
was
I
in
tried
court.
to be as patient as one
Okay.
possibly could,
and I
and I was.
and I
So your
understand.
motion to represent yourself is denied. Your motion to represent Mr. Mueller is, for your
I
motion
can't
to
represent
dismiss
him. He's an
Mr.
attorney.
Mueller is denied.
So I can't fire a lawyer I hired. Is that what you're saying?
That's correct. He will be your attorney.
So I get to go to get railroaded by a lawyer that's your friend and works with you and Stacy Collins.
Do you remember when you told me that Mr. Mueller was Batman and that Mr. Maynard was Robin, and you no longer wanted Robin and you wanted Batman?
So
Do
now,
you remember that?
yes, so now you send me to court trial defenseless because he hasn't done anything. So we got a witness in court right here. Terry, what has Mr. Mueller done? She can testify.
Rick, you're making a fool of yourself.
I'm making a fool of myself because
I'm
you
in
haven't
day
given me
5,
work.
I'm in day 5 of a jury trial, right now,
4
in
months
front of
ago,
this
you came to
jury.
see me.
And all of the motions you just proposed went where?
Where
Nowhere.
have all yours went?
All right, so this matter is over. Mr. Mueller, after this trial is over, could you please go and see Mr. Davis and start working on this trial?
The case actually has been worked up, Judge, and Mr. Davis has been informed of my view of the evidence, and it's my opinion that this matter will not resolve prior to the day before trial.
All right, so this trial is going forward on
So that means
February.
you don't come to see me?
This case is going forward on February 10th. All parties to be ready.
Thank you, Judge.
Thank you.